Good morning, you're Mark Ramirez. Give me just a second. And Mr. Ramirez, this is your initial appearance in cause number 25 DCCR 1362. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 24th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I talked to one, I forgot his name, I'm bad at names, but they said that they were gonna appoint.
Speak up, please.
They said they were gonna appoint one because my fiance talked with the DA and with the Keith guy. Something about trying to get a dismissal on the recommendation on my behalf, or if he's a see if I can get that person.
Okay, so who's your girlfriend? Is that Patricia Zamora?
Yes, ma'am.
Okay.
She was outside, but they didn't let her.
Okay, you do understand that there's a no contact according to your bond at this time.
It was set by the judge in Jefferson County for last month that it was how you say it was lifted. It was lifted last month.
Who lifted that?
I got the paperwork from the judge.
Well, but regardless of the protective order, there should be a, yeah.
Yes, ma'am. They lifted the protective order.
No, I'm not talking about the protective order. So a condition of your bond is that you not have contact. So there's two different things. There was a protective order that lasted a certain amount of time. That's over, the emergency protective order. However,
So I guess they never told her that either.
well, they don't have to tell her that. It's you. Hold on, I'm looking at some paperwork here. Okay, were you also arrested for driving while intoxicated at some point?
It's my lawyer.
So the magistration paperwork that's in the aggravated assault case is the DWI paperwork. Let me see. No, because it's got the interlock and May 24th. No, 2 different days.
It happened like in the 2 weeks prior in the same.
Do you have the auto ignition interlock device on your vehicle? Okay, if you'll make a note for Christy, I need the magistration paperwork for, can you just have a seat real quick, guys? I want to see the paperwork just to make sure that all the bond conditions are what they need to be on the correct case. So don't leave the courtroom, just have a seat for a minute. Is she here? Okay. Part of what I usually tell you to do, but what I am going to tell you is you probably can hold off on hiring someone. If everything goes well, you adhere to the bond conditions, she takes the class, then at some point, it looks like your case will probably be disposed of without the necessity of you hiring an attorney. It probably isn't a bad idea for you to start looking at least. And obviously, I understand that you guys, it looks like you're trying to work things out, but you're gonna have to not do that for some short amount of time.
Okay, I've been going through issues, the illnesses and everything, and then I took in her son at 5 months old because the father left. And I'm the provider of the house. And she don't have a job. She's a full-time mother. And I'm the one that pays for all the bills, all the food, everything.
So here's the thing. It's a second-degree felony. All I know is what you're charged with is serious. And I cannot feel comfortable without more information or some type of hearing. Now, if you want to go hire a lawyer, and they can file something to come in and have a hearing where everybody has notice of it. The district attorney can put on any evidence. If she wants to show up, she can. Then we'll discuss it at that point. But the only way to get that done is going to be probably to get, let me see, who's his court appointed? Who's his court appointed? I got it.
I believe it's sealed.
Mr. Parker? Mr. Parker was appointed to represent you while you were in custody. He is still your court-appointed attorney. Talk to him about all of these issues. He can file something, we can have a hearing, have her here, and then I will consider lifting that no contact. As of now, it's a no contact. So,
So that's what he can do it, that's what we can,
well,
just trying to go.
nothing's going, listen. You see how many people are in here today? I have that many people every day. I understand you've got a lot of issues. I'm trying to help you out. Talk to Mr. Parker. You have a no contact as of now, period. Step in front of the clerk, she'll give you a reset notice. In cause number 25 DCCR 1362, that is the aggravated assault with a deadly weapon. And if there was not already a condition of your bond that you not have contact with the complaining witness, which I believe there probably was, then I am imposing that condition now. I understand she's out there. Y'all need to figure out different places to live, different things to do until your case is resolved. Do you understand? That means no contact in person. It also means no communication. If she wants to discuss with the assistant district attorney or the district attorney an affidavit of non-prosecution or things like that, she needs to do that separate of you. You need to still go get an attorney.
She already did talk to the district.
Okay.
January the 8th, she starts the class.
She's going through the options class. Okay.
And that's why she told me that this court date was supposed to be.
Well, nothing gets dismissed until she completes that class.
Yes.
Okay, and so what they do is she goes through that class. If she still feels that that is what she wants to do, she will let them know that, and then that happens after the class.
Okay, so, I'm here for you, I had a good job, and with this case pending.
Okay, the case is, there's nothing I can do about the case pending. So your case is pending until it's resolved one way or the other. If that's, I understand, and it's also the time of the year where things go a little slower, like the options class isn't being offered till January and things like that. None of that changes what I'm going to set as your bond condition, which is the no contact order with her, okay? You need to, I'm going to reset your case to give you some time to see if you can get someone hired. If you get a lawyer hired before the next court date, bring the reset notice that you get today. They'll tell you what to do. If you're unable to hire someone, you need to talk to at least 3 lawyers and then bring me who you're talking to and we'll discuss your options. And then it might just take a couple of resets of this. If she goes through that class and the case gets dismissed, then you may or may not really need one, but I want you to be working on it just in case.
So, may I ask, if I did hire one, and it does get dismissed on the one that I
That's
put into
between,
the-
well, and so I typically wouldn't say that this, Ms. Malfino, do you guys have a way to check and confirm that someone has at least signed up for an options class in January?
Yes, ma'am. What's the
It's,
name?
what's her name?
Patricia Zamora.
Patricia Zamora on a January 8th. If you'll just double check that for me. Okay, have a seat again. Okay.
And it's in the bond conditions that there was no contact with her name.
Okay.
It says it in the
Just
thing,
saying,
so.
well, if- Okay, I'm gonna hold on to this for a second. Okay, so the test was negative. Mr. Ibarbo, you wanted to say something, sir?
You can address the court.
Yes, sir, I'm just, y'all are swapping alcohol drug out my whole life. I went through treatment. I reached a point when this case came about, everything, my whole life, the futility of it all was overwhelming. And, anyway, so I've been cleaning souls since July the 8th. I go to AA regularly. I like it. It's where I belong. I've got a sponsor today. I'm walking the steps. I'm pushing stone step 4. It was where I found a purpose that I've never had. And I think I could do well on probation. And, hopefully one day save somebody else from living another day, you know, what I've lived. Which is horrible addiction. Now that's all I got.
Thank you, sir. Mr. Coleman?
Judge, I'll be brief. I think the PSI speaks for itself as far as criminal history. I would like to add, I have judgments here. I've made them available to Mr. Kimler for additional convictions that were either not included in the PSI or they could not confirm those. And for the record, Judge, I am speaking of a 2013 aggravated assault out of St. Charles, Louisiana, in which the defendant received a 6-month probation. Also, a 2008 possession of a controlled substance case out of Kansas, in which the defendant was revoked to 20 months. In a 2013 fleeing or attempting to elude out of Kansas, for which the defendant received 5 days. I think that one is actually reflected in the PSI,
Okay,
the 5-day one.
yes.
Also, Judge, I have judgments out of Spokane, Washington for 1, 2, 3 thefts. One from 2011, 2 of them, it looks like it was a concurrent 1-year probation in 2008, and also a 2008 assault out of Spokane, Washington, in which the defendant received 338 days. And I've marked them. I'm happy to offer them.
No objection.
I don't know that I need them. I've made the notes and we'll take that into consideration as
Judge, that's all
well.
I have. I think the defendant, given his criminal history, it's a risk of sounding callous, Judge. I get it. People are struggle with drug addiction all the time. But at a certain point, Judge, there comes a point where the consideration needs to be protecting the public. This defendant's been having contact with law enforcement since 1988. And he has spanned at least 3 different states with his criminal behavior. Judge, he's fortunate to have a cap of 10. He's exposed to 20 years, Judge. I'm asking the court to sentence him to the 10 years.
$4.
I'm guilty of all that. I'm sorry.
Texas, Louisiana,
You're all right.
Kansas, New Orleans.
I'm very sorry.
I'm so- Arkansas,
6 or 5.
Alabama,
6.
I guess my biggest issue, Mr. Ebarbo, is, well, one of the biggest issues is I appreciate and am glad that you have done what you've done over the last few months. I think you probably started off doing that for the wrong reason, and that's because you got caught again and you're looking at 20 years in prison. It sounds like maybe you're doing better, and that's great. I just wonder why
Me too.
it's taken so long. It looks like you went to the Unity House back in 1986, and other than that, it's just, at some point, you've got to take responsibility before you commit an offense, not after. I've counted 24 misdemeanors. I think with some of the ones that Mr. Coleman has said, there's probably actually more than that. There were some records that couldn't be found from different states. They're probably looking at more like 30. 7 felony convictions. You've been to prison. It's just too much. And at some point, there has to be an end to what you're doing and get that help before you continue what you're doing. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 1722, find sufficient evidence to find you guilty, and at this time find you guilty of theft, find your prior enhancement convictions true, sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 2289, also find sufficient evidence to find you guilty, and at this time find you guilty of theft and find those prior enhancements true. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Thank you. Thank you, Mr. Kimler and Mr. Coleman. Thank you.
Good job.
Morning, Mr. Lane.
Good morning, ma'am.
I need your client to sign that, please. And are we going just on the counts for the DWI, or are we going on?
Just count one.
Just from the DWI, Your Honor.
Good morning, sir. Are you Dustin Drake?
Yes, ma'am.
And Mr. Lane, will your client waive the formal reading of the indictment?
Yes, Your Honor.
And Mr. Drake, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of driving while intoxicated, third or more, from July 22nd of 2024. It alleges that you were previously convicted of driving while intoxicated February 8th of 2012, and then again January 22nd of 2021, and June 22nd of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And are those prior convictions all true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, is that correct?
It's essentially a 10-year cap, Your Honor.
So the agreement is not to go
Pleading open
forward
to the third
on,
degree.
okay. So it is a plea bargain because, and there is a waiver of right to appeal because the prior offenses are waived, correct?
Correct.
And I did waiver, but we could do also plea bargain if the court wants.
No, this is fine the way it is. It shows that you did the waiver. I just want to make sure. I'm going to, just to make sure it's all clear as part of that plea bargain, if with their, well, on the unagreed page, I'm just going to write in with everyone's permission that part of the agreement was to go on just count 1 and not the prior others. That would make it a second degree.
Third degree.
Well, his prior felonies would make it a second, so that's what the plea agreement is, to go on count 1 only.
Oh, okay.
So I just want to make sure that that's on paperwork somewhere that shows that there was an agreement for something, and that's why he waived right to appeal.
Yes, sir.
Okay.
Probably, Your Honor. Thank you.
No, it's just complete as a lesser included. It's not.
Okay. And so there's no agreement with regard to, other than the fact that they're going on count 1 only. And so in effect, that means that it is up to me to sentence you in the range of punishment for that third degree felony, which is between 2 years and 10 years, you understand? And as long as I do that, then you'll be waiving or giving up any right to appeal. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first would be to determine if you're guilty or not, and then if they find you guilty, you could leave your punishment up to them. By going forward this way, you're waiving that and leaving it up to me, and is that what you want to do? All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Drake is not competent? All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Lane. He will present it to me on your behalf when we come back. On your way out of the courtroom today, you need to stop and talk to the probation department, and she's sitting at that desk right back there. Okay? Thank
Your Honor,
you.
I was
Is that
just going
mine?
to- Well, I was just going to ask if we could get, he has a full hip replacement Monday, and I think it's going to be about a 6-week recovery.
We're at least 6 weeks out, so if you want to do it January 26th, so,
Thank you.
okay, thank you. All right, be sure you stop and talk to probation.
Judge, with the court's permission, we're going to plead this to a lesser included. He has, over the recent months, provided ample documentation of his attendance in rehab and portable
Okay, thank you.
results.
All right, so are you Guillermo Galvin?
Yes, Your Honor.
And Mr. Crenshaw, will your client waive the formal reading of the indictment?
We do, Your Honor.
I'll get that pulled up. I'll take it. I'll take it. I keep pulling it up the wrong way. So paragraphs 1 and 2 then, to make it a Class A. Okay. Mr. Galvin, in cause number 24, DCCR 2321, the state's elected to proceed on paragraphs 1 and 2 only. Paragraph 1 alleges the offense that we're here for today, that you committed the offense of driving while intoxicated September 28th of 2024. Paragraph 2 alleges that you were previously convicted of driving while intoxicated April 30th of 2014. And how do you plead to that charge?
Yes.
And is that prior conviction true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for, is it a 1-year term, I guess?
Yes, Your Honor.
With everyone's permission, I'll mark that through, put that on here.
Please, thank you.
So it looks like the agreement that you've reached is for a 1-year term in the Jefferson County Correctional Facility, but that would be probated. You'd be on probation for 2 years. You would be ordered to pay a $4,000 fine, serve 1 weekend in jail, and follow all of the other rules and conditions of probation, also including having the auto ignition interlock device and a portable breath device. Is that your understanding?
Yes, Your Honor.
Are both necessary while on probation, or can we just do interlock?
We just need one.
Yeah.
Yeah.
He's done well on the portable. I'm just the interlock, whatever.
I think the interlock is what I would prefer to have. All right. With everyone's permission, I'll mark through that on the paperwork.
Thank you.
So you would be required to have the auto ignition interlock device on any vehicle that you drive. Do you understand? And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection?
It's admitted. Any evidence that Mr. Galvin's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated. Second, sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Correctional Facility, but I will probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine and to follow all of the rules and conditions of probation, including having the auto ignition interlock device on your vehicle. You will serve 1 weekend in jail. That will be the weekend beginning November the 28th. You'll be required to show up at the jail at 6:00 p.m. Don't be late. Don't show up under the influence of anything. Both of those things could be violations of your probation, and you'll be right back in here. Do you understand? If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that term while you're out on probation. The other side of that, however, is if you violate any condition of probation, you could be brought back in, and you would be facing that 1-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She will call you up when she's ready to go over your paperwork.